Your Honor, we're here because the state has alleged that a single piece of evidence ties Mr. Kohberger to this case. They've alleged that there's a knife sheath that has DNA that they allege matches Bryan Kohberger. He's now been incarcerated for 2 years, facing capital murder. The real story is exculpatory to Mr. Kohberger. He was not stationary around that house. He was never at that house. He did go to Moscow. He did drive around, but he wasn't over there. And the phone records absolutely show that. There's a reason why there's so much secrecy. That's because there's a violation of privacy rights. That's why there's so much secrecy. Your Honor, this is an extremely important motion, and the court is going to decide whether we do have any expectation of privacy left or not. The IGG evidence in this case should absolutely be suppressed. The court can see from the various affidavits in this case that there's a lot of things done that don't say how Mr. Kohberger was identified. And the reason for that is because nobody wanted to talk about what happened here with the genetic genealogy. That search was done by making a profile in Othram Lab. That search did not lead anywhere. We learned about investigative work that was done after Othram had done the work that they could do and before the FBI took over, that we learned about for the first time this week. Not through the motion to compel process. This was a giant secret. We know that by the time the FBI gets involved, the profile, the text file, that's a snip to use to try to identify somebody is more than twice as big when it gets to the FBI from Othram. We don't know.
Can you tell us why we're back inside?
When we get to the FBI, we don't know who did the work. You heard that any of that information is redacted. We don't know who did the work. It's a giant secret. The FBI took over the search, and from there they did things that we have no idea what it is. That part of this case is secret. We don't have any notes. We don't know who did any of the work. We don't have any lab protocols. We don't have any quality assurances. It's not reliable. You heard a lot of justice interim policy, and that policy it's on page 6 of that particular exhibit that the court has. It says that they're not to go into databases that aren't allowed. And they did that. The court has that in another exhibit. Finally, there was a trash pool in Pennsylvania, and there was no warrant for that trash pool either. All 3 of those stages of this case, there should have been a warrant, and there wasn't, and this must be suppressed. Your Honor, for the purposes of the Fourth Amendment protections and Article 1, Section 17 of the Idaho Constitution, we are looking to see if somebody has a privacy interest that society is ready to support.
Constitutional violation?
Your Honor, it goes to privacy.
Suppressed for contractual violations or even statutory violations.
Your Honor, I'm not sure what the court is asking me.
Well, it goes to whether or not your client has standing to complain about the searches of the databases because, as the state has posited, that wasn't his DNA that was searched. At best, it was his ancestors.
Your Honor, in this case, there were a lot of search warrants. I'm going to draw the court's attention to those beginning on December 23rd. That day is important because it was just a few days prior to that for the first time ever, Bryan Kohberger's name came up in the course of this investigation. Your Honor wouldn't know that by reading the affidavits for probable cause. Nobody would know that. That's because that information is omitted from the affidavit. That information is something that you heard about this morning in testimony, that but for the FBI's work going into databases they shouldn't have been going into, violating their own policy, keeping no records, and doing this all behind the scenes in secret. That's the only way a name was produced. Prior to that time, the lead detective in the case had not heard the name Bryan Kohberger. He had not crossed their radar.
Is there anything
that's nowhere in the affidavit, and that's important because that's intentionally withheld from the affidavit because of the work the FBI did, because the FBI went behind the scenes and did things that they shouldn't have been doing, because they searched databases that they shouldn't have been doing. We don't know what else they did wrong because everything else is a secret. We don't know what else they did wrong because there's no record kept. There's no process kept. We can't rebuild the process that they did to identify Mr. Kohberger. We can't do any of that because they kept no records, produced no records, and did this all behind closed doors, and it was withheld from the magistrate. Your Honor, the purpose we're here for today is to offer you a preliminary showing of why we should have a Franks hearing. To do that, we will show you that in this circumstance, the affidavits that supported search warrants in this case had false information in them that was intentionally placed there, there was intentional omissions of information that are material and exculpatory to Mr. Kohberger, and without the false statements and with the added information in, probable cause on the warrants should not be found. Today, I'm asking you to listen to what we have to say, look at the exhibits that have been admitted, and I'll walk through those with you to talk about the 13 areas. And at the end of this hearing, we will have met the preliminary showing required in order to schedule a Franks hearing and fully challenge this. So it's based on this false investigation trail, and it's based on statements that are completely out of context from somebody that they interviewed that are incorrect statements when you take the totality of the circumstances together, and statements that this person disclaimed a couple of days later because she wasn't sure what she remembered was real, and give that to the judge. If you add in the missing piece of IGG and what happened with that, and as a judge, you know you've got law enforcement willing to violate their own policy, and you know that you're not being told the full story about what a witness is saying, and you're being led down this path to say there's a real investigation when there wasn't a real investigation, you don't find probable cause on that.
We can start with the obvious issue. The obvious issue is that the FBI went through the back door or back window to dig in databases that the Department of Justice policy states they will try to avoid because, well, those databases don't want you in there digging through people's DNA to find them in crimes. And their customers are either already opted out of that because the company doesn't want it, or they've opted out of it for themselves. Okay. That's where we argued in court. That's where we argued. It was right there. But I think the bigger problem for me is that she and Taylor is stating that somewhere between Othram and the FBI, there was some unknown entity that did work. And when the sample leaves Othram, it's one size. When it gets to the FBI, the sample size has grown. So whoever that was in the middle, they've done some dilly-dallying there.
Go through these. I won't read them in their entirety to the court, but Your Honor asked the prosecutor what they were. And I counted up, and at the very first interview, remember the issue was whether or not one of the victims ran downstairs, and she didn't say it once. She said it 4 times in a row in the very first interview, and that just didn't happen. It just couldn't have happened, and that was not told. In fact, that statement was brushed over and withheld from the magistrate. About the memory issues in the second interview the same day, there are 2 references to not remembering. A couple of days later, there's the third interview, and there's references to not remembering, being drunk, a statement, I don't know any of it, like half the stuff. I don't know if it's a dream or if it's real. That's at page 399. At page 406, I don't know if this was real or in my mind was just like playing with me. But from what I think I heard, someone was crying in the bathroom. These are definite statements that were not given to the magistrate and in fact were brushed over. And credibility is really, really important when that person is relied on in the investigation. The credibility of the witness that they talked to, the one that they cited information from, that was relied on. That appears in these affidavits, and it's relied on after Mr. Kohberger's identified to say, well, he has bushy eyebrows, so this person has to be right. It's relied on when the police officers put into the affidavit the footprint that I didn't talk about on my first one. We gave the court the photographs of it. I'm happy to give the court these. That's a misleading statement to the court or to the magistrate that was asked for probable cause. This footprint is at the very edge of the door. It's a single footprint and it's not repeated throughout the house. So to act like that bolsters this witness important, especially in context of the misstatements of the witness. This probable cause affidavit talks about an interview they had where the person that was interviewed said that she heard things and saw things within her house. But what is written in the probable cause affidavit is seriously lacking in detail. It's wrong and it's false in many places. The way the affidavit reads, it says, this person stated she went to sleep on the second floor. She was awoken at 4 by what she stated sounded like one of the victims playing with the dog, which was on the 3rd floor. A short time later, she thought she heard one of the victims say something. That caveat, she thought she heard, is a problem. That's not at all what was said. This person was interviewed shortly after 911 was called in the afternoon of November 13th, 2022. And she was sure, I'm at Defendant's Exhibit 8A, page 281, lines 4 through 10, when this witness was sure that she heard this particular victim go up the stairs, and then come running back down the stairs. That is not what's contained in this affidavit at all. That is repeated during this same interview a couple of different times at page 287. It's also repeated in a subsequent interview that same day. This is Defendant's Exhibit 8B. That's at page 313 and again at 320. I've got one more of these where this is repeated. It's repeated again in D8C as well. That is important because that's misleading to the judge. That waters down what was said, and that matters in the probable cause affidavit because the officers, when they wrote this, knew that wasn't the case. They knew this particular person that DM said was upright and running down the stairs, but that's not what happened. That person was killed in the bed and never left the bed. And so the officers water that down because they know that fact is wrong, but they don't tell the magistrate that. They also don't tell the magistrate that this witness has claimed memory problems, that this witness has claimed that she's not sure what she heard or saw was real or whether it was at a dream, and that is contained in Defendant's 8C, and that's going to be beginning at page 396, 398, 399, 403. There's further statements from that witness in that police interview that said that she had too much to drink and couldn't remember. None of that is given to the magistrate. That is information that's withheld. That's credibility of the person telling law enforcement these things, and the magistrate had a right to know that whatever is laid out in here isn't exactly the way it was. That person had credibility issues, and she said things that were just absolutely untrue and couldn't have been true. Law enforcement knew that. That was intentionally withheld from the magistrate. That matters when we're talking about credibility and sets this whole thing into motion.
Her issue with Dylan is really multifaceted. Dylan said things that could not possibly have been true. They don't fit the physicality of the crime scene. She made a lot of assumptions. She held on to those assumptions so hard. They were the crux of her story. It was Kaylee that she heard running up and down the stairs. So that's one issue. But another is that she's simply not sure if any of this was even real. She doesn't even know. The man with the bushy eyebrows that she saw walk out the door, Dylan herself is not sure if that's real. That's quite a contrast to Bethany Funk, the witness who was left out of the probable cause affidavit. and feels very sternly that she knows what she heard and saw. She doesn't know exactly what it was, but she knows exactly how to describe what she heard and what she saw. To her, it sounded like a firecracker. And then she saw a sparkle. And she never changed her story and never questioned her own credibility. She's a much better witness, and she never made it into the probable cause affidavit. But the real issue with Dylan Mortensen is that up until the arrest of Bryan Kohberger, Dylan had an idea in her mind of who had broken into her house and killed KayleeGoncalves, MadisonMogen, EthanChapin, and XanaKernodle. And in Dylan's mind, it was Jack Showalter. She didn't know that Jack had given his DNA and that he had been cleared by DNA and alibi. She didn't know that. And at the time, all that was being said about Jack was that his alibi was he had gone to his parents' hunting cabin. In the middle of the night. Jack had actually gone home to his family residence, but it was being said that he had gone to his parents' hunting cabin. How many hunters are there out there? A gun and a knife. So there's that. And the only other thing that had been said about Jack at the time was that he'd run off to South Africa, which also wasn't true. But Dylan didn't know either of those things. So in her mind, her friends, Kaylee and Maddie, they were the kind of people who would tell a guy, you know, I have a boyfriend. Thank you, but no thank you, when they tried to approach them. And Dylan sees the grub truck footage. And when Maddie turns around and says, hey, mister, fuck you, Dylan's like, she's talking to that guy that no one knows except for her. And she's telling him, fuck you. And now Dylan is thinking, and then he says he went to his family's hunting cabin. And then he says that he had this pre-planned trip to South Africa. But none of those things are true. And Dylan has convinced herself that Jack Showalter is the guy she saw in her house.
If the magistrate had the other facts, I think the magistrate would have some serious concerns and would not find probable cause. Your Honor, the vehicle, and I know the court knows what I'm going to say, there's not DNA in that vehicle that was brought out from a crime scene. This absolutely matters, Your Honor. If you want to go to the state's theory, right, with their videos that they've talked about, they told the magistrate about, that this is the video, this is what matters. It parks at this certain time, it leaves at this certain time. If you want to go to that, there's about 13 minutes of time, right? 13 minutes between the last time you see the car and the next time you see the car on the video. And if you end up with a car that's searched, and I mean searched and taken apart, the brake is taken apart, the gear shift is taken apart, the key fob is checked, there's no blood on any of that, none. The steering wheel, there's some kind of spray all over the interior of the car to check for it. There's no blood. I think that there's context that the magistrate should have known that's absolutely exculpatory to Mr. Kohberger, and it matters a whole lot. There's also no, the identification to the sheet that maybe seems like it would be really good. You don't really even know how that happened, and you don't know how it got there. This isn't like DNA in blood on the wall from Mr. Kohberger. That's not there. That doesn't exist in this scene. You're talking about an item that the question of how should be, especially when you know about the other male DNA in the house, and especially when you know about the lack of DNA connections. If the magistrate judge had been told there's unknown male B in blood in the house attached to the handrail, that might have made more of a difference to her. Maybe a sheath that can be carried to the house and blood in the house that's not the same, maybe that matters. And then maybe the car being completely empty of any blood DNA connection, maybe that matters a little bit more. Law enforcement in their affidavits talked about this dog barking, and they key some time, and they say this is when something was happening inside this house. We can hear this dog barking, and they use the videotape to get a time off that surveillance tape from the neighborhood, the 1112 King. And so they've got this time, but they also have this video, this trail that they've picked out a time that something probably happened here, and they don't tell the magistrate that this dog that's barking continues on long after the car they're interested in has left the area and then abruptly stops. Your Honor, the dog was found the next day inside the house in a bedroom with an open door, where the other bedrooms that contained people that died, their bedroom doors were open, and this dog had not tracked any blood around. The dog had no blood on it whatsoever, but it was just sitting in an open room a day later. The magistrate is not informed about that either. I think the most prominent question is, how did that sheath get there? And I think when you ask that question, I think you can have DNA on an object at a scene when you know about all of these other things and you don't find probable cause, because there are more questions than there are answers. And all of a sudden, this one thing doesn't look as big. It doesn't look as everything pointing to it when you have the context around it. The magistrate didn't have to have every detail of the case, but knowing how many attempts to find a DNA connection there were, and it didn't exist in Bryan's car, in Bryan's apartment, that there's no other DNA in there other than unknown male B that we know of for sure, and unknown male D outside. There is a lot of context there, and all of a sudden this one thing, the question of how is that there, is the question that the magistrate should have had. And then we come to all of the other things that we've talked about.
There's no connection and no DNA in Bryan's car, apartment, office, his family home. And that works so nicely for the defense. How that can be explained away? Well, there were a lot of rumors, but we don't know. And Bryan said he was guilty, so that's pretty amazing. Incredible. However, there's this issue because the roommates, they kind of align when a time is happening. But Anne also understands that the 1112 King Road camera footage, what they're hearing there, the dog barking, the whimpers, the voices, the thud, whatever is happening there, that they're using that to pad the fact that Dylan and Bethany have the right timeline. And it would almost appear as if that's because Dylan's not even sure if this was real in her house. So you need something to kind of back that up. But is that a thud at 4:17 a.m. or is that the firework that Bethany said she heard? And does that mean that your timeline is off? Because the dog begins barking very aggressively after the thud or the firework, and it continues on for almost 30 minutes. So does the dog barking indicate the close of your timeline, like the state says, or does it indicate the beginning of a timeline that Ann Taylor is trying to lay? And then there's a set, like using a math term, a set of unknown male DNA in the home. So A, we would assume is Bryan on the sheath, and well, no one debated that. B, the handrail to the first floor. C, I would assume is the nail clippings of MadisonMogen. D, the gloves outside of the residence. More than one, check the court transcript. But there's no DNA in Bryan's car or his apartment that he went to immediately after the crimes, or his office that was located near his apartment, or his family home across the country where he took many items from his apartment when he went home.
The fact that Mr. Kohberger gets arrested, his apartment gets searched, his car gets searched again, and his car gets searched again, and there's absolutely no connection between him and anybody from 1122 King. I mean, that's the ultimate question that will be before a jury. What does that mean, right? What does a knife sheath at a scene mean? That's going to be the ultimate question. You're
Killed by a knife, that probably means a lot.
It might mean a lot.
Probable cause is not a proof beyond a reasonable doubt standard. It's probable cause to think that this person might have done it. And I'm not sure how that direct DNA connection to a sheath found on or near one of the victims doesn't close the book on anything on probable cause after that. Even if disclosed. Preclude a finding of probable cause when there's a DNA match between the DNA and the sheath in Mr. Kohberger. Isn't that probable cause every day and twice on Sunday?
I don't think probable cause is in a vacuum. I think probable cause isn't one thing. I hope it's not one thing. I hope there has to be a little bit more than one thing, especially when you've got another thing that's the same as the one thing.
Well, I said I wouldn't do this, but I'm going to do it anyway, because you brought up blood DNA of an unknown individual that was found, I think, on that handrail.
Yes.
Doesn't that necessarily not exclude Mr. Kohberger? What it may do is suggest there might be a potential other person in addition involved if you assume that that blood was related to the victims and not some earlier event in the house.
If what the court is saying is exactly why the magistrate needed to know that. Is there another explanation here? I've got this sheath, but there are all these other things that if I know about them matter. What's the other explanation? What's going on with this investigation? What's happening here? That's exactly the point, Your Honor. What other explanation is there? The magistrate wasn't given a chance to ask that. She wasn't given a chance to ask that when she wasn't told about unknown male B, blood on a handrail. She wasn't given a chance to ask about that when she wasn't told about unknown male D, blood on a glove right outside the residence. She wasn't given a chance to ask any of those questions. She didn't know that Bryan's car, and the court's question, good question, what does that mean? Could it mean there's one person? The answer to that is, or it could mean it's not Bryan because his car's got nothing in it and there were only 13 minutes to do this. The magistrate didn't get to know that.
In fact, his DNA is still on the knife sheath, though. That's the problem, counsel, for probable cause purposes.
If that's the only thing she's told, I can see why she'd find probable cause. It's these other things that are withheld that create a context around it. I think the purpose of Frank's is to ask this very question, and this is a question. What do we want to do with our criminal justice system? Do we want to have one thing with no context around it when there's this other context that really matters?
The Frank standard, which is, even if you add that stuff, does that take away probable cause, counsel? And my problem is, once you have a direct DNA tie to the defendant, for purposes of probable cause, this isn't for purposes of conviction, for purposes of probable cause, you have not explained to me why a reasonable magistrate, let alone any magistrate wouldn't find probable cause there, even if they knew all those other facts. As to Mr. Kohberger, now, there may be, as you say, other people that creates concern or issues about that need to be investigated further. But I'm not sure that that diminishes the probable cause as to Mr. Kohberger if his DNA is found on a knife she found on or near the victim, who was stabbed with said alleged knife that would have been in said alleged sheath. There are other things in the affidavit that, or affidavits at that point, that could explain that, including the wearing clothing and covering gloves and all that that could be put into a bag real quick on the way out that was in one of the affidavits.
And her main point, to wrap this all up, is genuinely, get this, two things. One, I indicated to the state that I knew what was going on with Bethany Funk, that I knew she had given statements that would lie outside of what they were accusing my client of. A firecracker, a sparkler. Dylan is now saying that she thinks he was carrying a gun. You go in and arrest my client, and you confiscate his Glock 22. You want to bring in statements that he made when he was arrested, and one of them was that he had the Glock 22 near his bedside. We have one thing, right? The K-bar, the Bryan, the thing Dylan says she saw and heard. But then we have another thing. The Bethany, the firecracker, the sparkle, the gun that Dylan is now convinced this person may have been carrying. She didn't think so at the time, but she does now. And before I could present that in front of Magistrate Megan Marshall, who made the actual decision on whether or not there was probable cause to arrest my client, the state conducted the impaneling of a secret grand jury and indicted my client, disabling me from having a preliminary hearing in front of Magistrate Megan Marshall so that I could bring these things forward and make these witnesses talk about what it was that they said, what it was that they heard. And that's all, without mentioning the things that couldn't be tied back to Bryan Kohberger.